All right. So the sound should be working now, but just through one of our devices. I have to add a few more devices here. Ms. Nelson, can you hear us now?
Yes, sir. Can hear you.
Okay. I don't have the magic email that tells me who is in what booth. Did you get one of those?
Yes, I'll send it to you, Judge.
Thank you. I'm going to add a few more devices. It can take just 1 second. Bear with us, please.
I'm sending it. Ignore that first one.
Okay. Ms. Wood or Ms. Feely, are you on the call? Yes, you both are.
Good afternoon, Judge.
Hey, so neither of you, I don't need to activate the defense table camera. You and Ms. Feely will both be virtual?
Yes, Judge.
Great. All right, we may have everything we need then. Let me close that and look for my other magic email. That's not it. Well, we'll get started. If I get that email telling me where people are, that'll make it a little easier to track people down, but we're going to go. Well, do we need to do Wilcox first? Because we've got DOC plugged in, Ms. Nelson?
Yes, Judge, please.
All right. I don't know who that is. Who is in Wilcox?
Position 7, Tony Clark.
Clark.
All right. I see him. Great. Let's spotlight that. All right. How you doing, Mr. Clark? Can you see me and hear me?
Yes, I can. I'm doing terrible. Great, great.
Well, gosh, those are opposite. Which one's it going to be?
It's just complete.
Okay, well, I'm going to ask Ms. Feely what's going on with your case. We had status conferences in August and September. Where are we, Ms. Feely, in terms of moving Mr. Clark's case along?
So the September date was the one that I did not attend unexpectedly, but I have the discovery, I have an offer from the state, but I think this is one Mr. Clark and I have discussed. My evaluation of the case is different from the state's, and I think they may have some more trouble than they think proving some of this stuff. So we're hoping to get Mr. Clark produced to Rice Street so that we can prepare more thoroughly for trial in person.
Okay, Mr. Clark, you are in Wilcox. Remind me why you are there.
Probation violation.
How much time remains, as best you know?
Maybe 6 to 7 months.
Okay, Ms. Feely, do you want us to try to get Mr. Clark here sooner? I mean, you are busy between now and the end of the year, that I know, with the trial calendars. Should we try to get Mr. Clark here early 2023?
I think, yes, I think we wouldn't be able to get to him this next round of trial calendars. So, but I would hope to get to him early in 2023.
Okay. And does Mr. Clark have a bond in this case, or if for some reason he gets released early from DOC custody because of whatever, would he naturally come back to Rice Street?
Yes.
Okay. So we'd just be getting him here a little early if you'd be in a position to work with him.
Right.
Okay. Mr. Hand, anything you want to add in Mr. Clark's case?
No, Judge.
All right. What we'll do, I'm going to have a tickler for Ms. Nelson to check in with you, Ms. Feely, early in the new year. I'm talking January, about your capacity to engage with Mr. Clark if we had him produced early. If he has only 6 months left, he may get back here anyway by the time you're in a position to plug into his case, okay?
Yeah, so his max out date is June 15th of 2023.
Well, we would want him here before then, but that's the max out date. And sometimes these calculations work in mysterious ways.
Right.
What she said was,
All right. Mr. Clark, any questions?
can I hear that max out date once again?
So this is just from what's published in the Department of Corrections website, but it's June 15th of 2023.
Okay.
All right. Anything else, Mr. Clark?
No, sir.
All right. It's good seeing you. And we will get you back to Fulton sometime early in the new year, unless you get a release date before then, and then you'll come back sooner. Okay.
Why is it good seeing me?
Well, I hadn't
Just
seen you.
kidding.
Yeah, there you go.
Just kidding.
All right. But you didn't get me. It was the apple on the side of your head. I missed that, but we'll see you soon. Okay.
All right.
Bye-bye. Thank you, Wilcox.
You're welcome.
All right. Ms. Livingston, now that we are done with our one DOC, is it most effective to go through in the order the calendar is published, or did you have a different way you wanted us to do it?
We could just go down the calendar, Judge, because courtroom 3, they're not ready yet.
Okay. All right. Then I know where to go first. Are you Mr. Kendrick?
Yes, sir.
Good morning or good afternoon. How you doing?
Good afternoon. I'm doing all right.
Good. Let me get you on the spotlight there. So this is plea and arraignment. Let me all these different emails with info. So Ms. Wood, this is your case.
Yes, Judge.
Great. This is plea and arraignment for Mr. Kendrick. Is he waiving arraignment? Are we resolving this case based on the nature of the offense, or where are we?
Judge, Mr. Kendrick does want to resolve. However, he has a 21 CP case that's still out there. And unfortunately, I have not had a chance to talk with the state about waiving that and resolving everything globally. So I think for today, it's probably going to be in his best interest to waive arraignment on this and just get with the state and see if we can get something worked out within the next couple of weeks.
Got it. So Mr. Kendrick, the case that's been indicted charges you with family violence battery. That's the one that has been assigned to me. And I'm Judge McBurney, by the way. I should have introduced myself. You've got one unindicted case, and Ms. Wood is wisely looking at whether you could resolve everything at once rather than you sort this one out. And then your other case charges you with entering an auto and theft by taking as the two felonies. And that case is stuck in unindicted land. That doesn't mean that the prosecutor here, Mr. Hand, couldn't accuse it if that's what you want to do so that everything can be worked out. But that's how we're going to move forward. Does that make sense? You have any questions?
No.
Okay. Well, we'll move that along as quickly as we can. Ms. Wood will file a waiver of arraignment on your behalf. Mr. Hand, the prosecutor, is going to get discovery to her on the family violence battery case. That can get the two lawyers starting to talk so they can see if it makes sense to take care of both your cases. All right?
All right.
Judge, this.
Hold on one second.
Okay. Judge, this case will be handled by Mr. Whitenauer.
Okay. He was stuck in another courtroom. And I have a long list of participants. Mr. Whitenauer, are you with us now, or are you still in another courtroom? He's still in another courtroom. Nonetheless, what I described remains the case, Mr. Kendrick. A prosecutor will be getting discovery to your lawyer, Ms. Wood. She'll get with you. And there actually may be two prosecutors for you. You've got one because there's a domestic violence matter, and Mr. Hand would likely be the prosecutor who handles the entering auto case. But same basic scenario, all right?
Yes, sir.
All right, you're free to go.
Thank you.
Judge,
Yes.
the inmate on the spotlight right now, he's actually not position number 2. He's position number 3. He didn't go in the right booth. So this is Mr. Kelly that's on the spotlight.
Got it. Thank you so much. Hey, Mr. Kelly, how you doing?
Hello, blessed, and you?
I guess I'm blessed too. I'm glad you are in one of the booths, and we're going to talk about your case anyway. Let me figure out what we've got here. You've got Ms. Wood as your lawyer as well. Ms. Wood, good afternoon.
Hi, Judge.
Is Mr. Kelly going to waive arraignment?
Judge, we're trying to work this one out. I just need a very brief breakout session with him today, if possible.
Okay. All right, we've got Ms. Charles here in court representing the state, so let's see if we can do that. Mr. Kelly, Ms. Wood is your lawyer. I don't know how much time you all been able to spend together so far, but she has been talking with the prosecutor about possibly resolving your case. So I'm going to have you stay right where you are. Something is real loud. And I'm going to move your camera and audio into a private room with Ms. Wood. and you guys can talk about your situation, and then you're going to come back and join us virtually, okay?
Yes, sir.
All right, let me see if I can make this happen. Let's see what happens. All right. They're gone. Sums up with one. We are going to do Mr. Muckle next. Mr. Hoover, I think I saw you on.
Yes, Your Honor, I'm here.
All right, let me get Mr. Muckle. So I don't have a 7 South. Oh, there it is. Mr. Muckle, can you hear me?
Yes, sir, I can.
Great. Good afternoon. And let me add Mr. Hoover so you can see him. And Mr. Abate, Mr. Muckle is your case. Great. This is on for a status conference, meaning we need to talk about when we can get Mr. Muckle's case to trial, assuming that's the way it's heading. Mr. Hoover, how are you doing with discovery from the state?
Your Honor, I believe I have all of the discovery from the state. The issue that I'm running with is not with the state. It's with, because of the age of the case, reaching out to certain people that are involved in the case has become difficult, but everything from the state is fine right now.
Okay, good to hear. When might you be in a position to say ready for trial? December is already spoken for, so January, February, we're looking to start filling those calendars. But I certainly want to give you time to run down the leads that you and Mr. Muckle have been discussing.
I would say February will be more than enough time for Mr. Muckle and I to have an answer for that.
Well, my question is, what trial calendar should I put you on?
Oh, okay.
So I'm not looking for an answer in February. I'm looking for a trial in February or whatever month you tell me. I want to accommodate within reason your schedule and your needs to work on the case in the way that you and Mr. Muckle have discussed.
I would say February would be better than January for us.
Okay. I just got a note that we already have filled January and February. So if we did March, it sounds like that just gives you more time and that's less problematic.
I would say yes. However, I'm on the YSL case and the state is asking to start that trial in March.
Sure. And then you'll be gone for 6 months is what everyone is saying. So it is my fervent desire that Judge Glanville takes the federal approach and says, all right, state, you pick the 6 defendants you're going forward with first. And if you're one of those 6, Mr. Hoover, we'll see you in the summer. If you're not one of those 6, then we can get you in March. So we will put Mr. Muckle in the March trial queue, understanding that if you get orders from Judge Glanville that you're going to spend the next 3-4 months doing YSL, that's what you're going to be doing. A number of judges will see their schedules dislocated by that one.
Thank you, Judge.
You bet. Mr. Abate, any reason why March wouldn't work for you in the Muckle matter?
No reason at this time, Your Honor.
All right. Mr. Muckle, any questions about what we've just discussed?
No, sir. Not about
Okay.
that.
Well, you know who you need to reach out to, and that's Mr. Hoover. If you've got questions or concerns, don't feel like he's abandoned you if he's not in touch right away, because this trial, again, wouldn't be till March. But as we get into the new year, you'll be seeing much more of him as you and he get ready for trial, with that one caveat that Mr. Hoover wisely shared. That YSL case, if it goes and when it goes, it's going to absorb a few attorneys for a while. We just don't know which ones. There are however many defendants, 20-something defendants in that. They can't all be tried at once. So the judge is going to have to break it into more bite-sized pieces. All right? If you don't have any other questions, Mr. Muckle, you're free to go. And Mr. Hoover, if you don't have any other cases on this calendar, you are similarly free to go.
Thank you, Judge. And Mr. Muckle, I will see you on Friday.
Yes, sir. Thank you.
All right. Sounds good, gentlemen.
Yes, they brought them to a cell. They all want to sell. I'm gonna join right here.
All right. And when Ms. Wood, you're back, you should speak up because I can't see necessarily that you're back. Let's go to our next status conference. It's 2 positions.
Where my son at?
So Ms. Wolf, you need to stay muted, okay? Mr. Conley, can you hear me?
Good morning, Your Honor.
Good afternoon. I'll take that as a yes, you can hear me.
Yes, sir.
I'm not clear on who is representing Mr. Conley. I've got Mr. Johnson listed on one case and Ms. Wood on another, which is a little confusing. And we may not have Ms. Wood back yet, so I may have jumped ahead of things here. Mr. Hand, do you have both these cases?
I do, Judge.
Okay. Have you been working with both Mr. Johnson and Ms. Wood on this?
So I similarly saw Mr. Johnson listed for one case, and so I sent him discovery for that one case.
Yeah.
And then I sent discovery to Ms. Wood for
Okay.
the other case.
We're going to tap the brakes on Mr. Conley. Ms. Wood is still in that breakout room. So Mr. Conley, we're going to come back to you. Don't go anywhere. We just need to make sure.
Judge.
Oh, you're back. Excellent. So could you share with us if you are handling both, one or neither of we're talking about Mr. Conley, he's positions 5 and 6.
Judge, Mr. Conley's cases, this is one of those situations where the conflict defender's office sent back the second case, so that's why I have it. The actual conflict is on position 5.
Got it.
Not sure if Mr. Johnson's on the call. I had reached out to him about seeing if we could coordinate on a global resolution. So that's what I was waiting to see where he was on this case, on his case with Mr.
Ms. Nelson, if you could reach out to Mr. Johnson to see if he's
Your Honor, I'm on the call.
Oh, he's here.
Your Honor.
Woo!
I'm on the
All
call,
right.
Your Honor.
Okay, I got you. Let's add you to the mix. There he is. The standard background. He's in his bat cave. So Mr. Johnson, we're talking about Mr. Conley, who you can see on the screen there. And in a mysterious move that preceded you in this case, the conflict defender's office said, yes, there's a conflict on position 5, so we'll keep it, so you have it. But there's no conflict on 6, so why would we keep it? Well, because it's the same client, but it's with Ms. Wood, and she is working on that one. And it sounds like she had wanted to talk with you. And then we've got Mr. Hand here in court about a global resolution. It's on for status conference. So this would be the day, if there is a global resolution, when Mr. Conley could enter a plea and withdraw that plea if he was unhappy with whatever sentence he got, if it was higher than what the defense attorneys asked for. But other than that one sort of final plea piece to things, if we can't sort things out today, it just means we'll put it in the queue for, I'm now learning, the March trial calendar, which gives you a pretty big window to still negotiate things. There just won't be that final plea right. So Ms. Wood was saying she's looking to try to sort things out. Her case looks less complicated than yours, Mr. Johnson.
That is true, Your Honor. Just recently, Ms. Wood did reach out to me, send me an email with regards to a global resolution on this case. And as Mr. Hand stated, he has just recently also sent out the discovery to me since I've been appointed to this matter. I'm still in the process of reviewing the discovery for Mr. Conley, but I do believe that a global resolution for both of these matters would be something that would be easy to be worked out with Mr. Hand, Your Honor. Just will not be able to do it today, but I do believe that that is something that will be able to work out within the near future.
Okay. I just got this news in. It was only Mr. Muckle's case that from this calendar we're working through today that wasn't already tentatively assigned to either January or February. Mr. Conley is on the January trial calendar, which is great. That's just a spur to keep people focused on it, and a backstop so that if there's not a global resolution before the January calendar, there'll be one then when we call it. But that'll give Mr. Johnson a chance to work through the discovery that he only recently received because he's new to the case, because Mr. Hand is new to the case. So Mr. Conley, a lot of moving parts. And normally you don't have two lawyers, you just have one, but you benefit from having two here. They work well together, so that's not going to work to your disadvantage. But it just means we need to get one more person involved in that stream of communication. Your case will appear on the January trial calendar. It's my hope that before then we may get you here in court and you can work out both cases. All right?
Yes, sir, Your Honor.
Do you have questions about anything we just talked about?
Yes, sir. I still haven't received the discovery from my aggravated assault case. I've been sitting on sit 15 months on my case. I turned myself in, like I did everything that I was supposed to do, but I still haven't received any confirmation from my discovery to like anything. Like I really don't know what's going on right now. So
That's going to change. That's going to change real soon, Mr. Conley. You have, through nothing you did, you have suffered through some lawyer transitions. The conflict defender's office that handles your aggravated assault case, since you've gone into custody, I think they've gone through 3 lawyers. But Mr. Johnson, who is now the conflict defender for my courtroom, has made it real clear that he's here to stay. And as soon as he gets these discovery packets, he goes and meets with his client. So he very recently got the discovery. I'm going to be quiet for a moment because he's going to tell you how soon he can come see you to get you exactly what you're asking for and to have that conversation. Okay?
Okay.
I will be out to see you within the week, Mr. Conley, with all the paper discovery that I'm able to provide to you.
Okay.
So I want to qualify that in one way. You heard Mr. Johnson say all the paper discovery he's able to provide you. It may well be, for example, that there's body cam footage. Mr. Johnson can't print that out as a video. If it's real important for you to see the body cam footage because there's something central to the case in it, then Mr. Johnson, number one, can get an order from me that lets him bring a laptop over to the jail, or it might be we're bringing you over here for something and then you could watch the video over here. But Mr. Johnson will certainly get you all the paper, the police reports, witness reports, anything like that. He'll get you all that when he comes to visit you within that week or so that he just described, okay?
So that's for my misdemeanor.
Well, you don't have a misdemeanor. You've got an aggravated assault. You allegedly shot at someone. That is the case Mr. Johnson has. Ms. Wood has the case where you allegedly damaged some property. Ms. Wood, do you have all the discovery in that case?
Judge, I'm missing surveillance video and photos that are referenced in the police report, but I think we can work it out without those things.
Okay. And if it becomes something central, you'll bug Mr. Hand, and I'm sure he'll get you those materials.
Yes, Judge.
Okay. Is that your other case, Mr. Conley, or are you thinking you said misdemeanor several times? You don't have a misdemeanor case with me.
I apologize, Your Honor, because I'm thinking it was my misdemeanor case, but these are my 2 felony cases. I'm really just ready to move forward. I've been fighting this aggravated assault, Your Honor, since 2020. I did everything that I could possibly do. I'm just really ready to wrap it up.
I hear you. And both your cases are actually from 2020. I'm now looking at the other one, and the allegation is that you busted up one of those video poker machines at a Quick Mart, but back in May of 2020. So I understand now why Ms. Wood is saying it's a pretty resolvable case. So my request to you, I know you've been very patient, but wait till you and Mr. Johnson can meet. He's going to bring you the discovery in your ag assault case, and you can engage him in exactly what you want to do right now, which is, look, I want to work this out. There's a misunderstanding here. Whatever it is you want to share with him, you can have that conversation. That will equip him to reach back out to the prosecutor to say, let's work this thing out. Okay?
Okay.
All right. I appreciate your patience. Mr. Johnson's going to come see you. It sounds like Ms. Wood will come see you as well, so you can get the discovery in that other case, which is by all accounts a less serious situation. All right. Thank you, Mr. Conley. You are free to go. Expect a visit from at least one, if not both of your lawyers in the next week or so. Okay?
Thank you too, Your Honor.
All right. Bye-bye.
All right. Have a blessed day.
Ms. Wood, should we go back to Mr. Kelly? What's happening with that?
Judge, is he back? I don't know if he made it back.
I may need to pull him out of the breakout room, which I'll happily do, but just tell me what we're doing next.
I need to send an email to Ms. Charles really quickly, and then we might be able to move forward on that one.
Why don't you do that? And I'm going to keep moving through the calendar and just let me know when we need to pull him back in.
Thank you, Judge.
Sure. 847. So we're doing Willie Williams next. Turn his speaker on. Good afternoon, Mr. Williams. Can you hear me?
Oh, yes.
Great. How you doing?
I'm fine, sir.
Good. Just got a note about where people are, but I think I got it. Ms. Wood, I know you're trying to reach out to Ms. Charles, but I think Mr. Williams is your case.
It is, Judge.
Okay. How are you doing with discovery in his case?
Judge, I believe we have initial discovery. This is one. Did you say this is going to be on the January trial calendar? I'm sorry if I missed that.
I didn't. I don't have that visit. I know it will be January or February. What I was told is that everything but Muckle is January or February.
Okay. The reason I ask is because I do expect a non-trial resolution in this case that would also include a program. We are in the midst of working to get that lined up. I just don't have it squared away just yet. So I'm hoping we can get him back on a calendar, soon to have a plea.
Sure. What we do, I just got the note. So Mr. Williams is on for our January calendar, which is a great backstop. If you and Mr. Williams and Ms. Patterson don't line something up before then we know certainly by early January, we're going to need to do something or we'll do a trial. And it sounds like you've got sufficient discovery for you to be able to move forward.
Yes, Judge.
Okay. Mr. Hand, is this your case?
Yes, Judge.
Anything you want to add in connection with Mr. Williams's case?
No, Judge.
You're ready for it to move forward?
Yes.
Mr. Williams, do you have any questions about what we've been talking about?
Yes, I thought I would go in the drug court case.
So it may be, when Ms. Wood said program, drug court certainly a program. It's a great program too. Because your charge is aggravated assault, that may make it more complicated for you to get into drug court. That doesn't mean you cannot, but the folks at drug court would need to make sure that it would be safe for you and for other participants in drug court to be together. But Ms. Wood, maybe you can speak more to what the landscape is looking like right now.
Judge, he was referred to drug court. I'm just waiting to hear back as to whether he'll be accepted or not.
Got it. If you are finding a delay, please let me know and I will lean on the right people at drug court so we can get an answer sooner about whether Mr. Williams has been accepted. Would this be a drug court as a condition of probation because there's a plea, or is this a diversionary drug court, Mr. Hand?
Judge, I'm not certain. I think there was a discussion about drug court that predated me, but I need to talk to Ms. Woods.
Got it. Ms. Wood, what do you know from discussions you've had?
if he qualifies for diversion, that would be my preference. I'll have to double check his GCIC as well, Judge. So either diversion or plea.
Okay, sounds good. So Mr. Williams, you asked a smart question. And it sounds like folks are at drug court are evaluating your application right now. Ms. Wood will let me know if they're taking too long and I'll fuss at them a bit. I'm one of the drug court judges, just so you know. I don't want you to feel like I'm stalking you or something, but if you get into drug court, it may be that we work together while you're in drug court, okay? Anything else?
How long will I be, when I go come back to court?
So if you get accepted into drug court, you'll either come back here in the next few weeks, or if it's what we call diversion, you don't even need to come back here. You'll go straight from where you are to orientation, which happens on a Wednesday. So it probably wouldn't be next Wednesday, but it might be the Wednesday after that. Okay?
Okay, if I do get accepted, it'll be next Wednesday.
We'll see what we can do. All right, Mr. Williams, thank you for your time.
Okay, and that'll work when I be back to court.
Say that again?
When I be back to court, if I don't get in.
If you don't get into drug court, then it sounds like Ms. Wood and her team will have to look for a few other options. They're going to need to talk to you about that. So you would see them before you'd see me. But as soon as they find a different program, if drug court doesn't work, then they'll want you to get back to court. So my guess is that would be more like a month rather than just a week or so, if drug court says no, thank you.
Okay.
All right. Anything else, Mr. Williams?
No.
All right. I can tell you're ready to go. Let's hope drug court says yes. Okay.
Okay.
All right. Thanks. You're free to go. So Mr. Williams's case will be on that January trial calendar, but it sounds like everyone is working hard to have a non-trial resolution well before then.
I agree, Judge. And I've looked at the allegations. It doesn't appear to be the most serious.
Seems like drug court should say yes to this. Okay. Well, again, Ms. Wood, please don't hesitate to bug me. It's not bugging me. Let me know if there's some delay in getting a response from drug court.
Thank you, Judge.
All right. Let's keep moving on. Mr. Whitenauer, have you joined us yet? All right, we got to hold off on 9. Mr. Hiles, are you with us?
Yes, Your Honor.
Great. We're going to jump to position 10 then. Let me find that. Mr. Williams, you don't need to stay in there anymore if you don't want to.
Okay.
One. Hey, Mr. Wolf, can you hear me?
Yes, sir.
Great. Mute a couple other things here. There we go. And let me get your lawyer right next to you. There he is. All right. Good afternoon, Mr. Monetis. How are you?
Good afternoon, Judge. I'm doing well, thanks. How are you?
I am all right. Mr. Wolf has 2 cases. Only one of them is on the calendar, but that is just an oversight on our part. The cases will be moving together. The one that's on the calendar is the more serious one, and I assume the one that we would be trying if something's going to be tried. Mr. Monetis, have you received discovery in Mr. Wolf's case?
Yes, Judge, I have. I received discovery and I've organized it. I've gone through some of it with the defendant, but I haven't gone through all of it. And then there's more of it that I need to digest. But ADA Hiles and I have discussed having a meeting sometime soon and try to see where things go. And, you know, apart from that, I can be ready with my particularized motions on a motions date, Judge.
Okay, so your sense is not that you're missing any discovery, it's just there's a lot of it and you're working through it.
Yes, Judge. And then I imagine, customarily discovery, drips in later on. And I guess 88 House and I can talk about that.
Okay, when you say we would have a motions date, I don't know what's at play in this case. Did Mr. Wolf allegedly give a statement, or was there a search? What kinds of things would we be litigating?
Yeah, I will. Yeah, it's wise to ask me about that, Judge. It does seem to be on the lighter side of things. I don't believe there was a statement. I don't believe there's any physical evidence that Mr. Wolf has a standing to press, but there might be a cell phone records, and then just eliminate. And then based on my knowledge of his open cases, I imagine we might have some kind of that yet.
Okay, you got a little choppy there, but I did hear you say that it doesn't look like there'll necessarily be a bunch of motions. This is actually the status conference. We passed the motions deadline. That's not me telling you you can't file anything. Certainly if something was late produced and it took you then some time to work through that, that would be a reason to file a late motion. But I'm making this up because it sounds like it didn't happen. If Mr. Wolf gave a confession and you already had that, the time to have filed that motion has passed. And so I want to make sure we continue to move this forward. And it sounds like we can. Ms. Nelson, is this tentatively set for the January or the February calendar?
This is on the February 27th supplemental trial calendar. And the other 3 cases Mr. Wolf has, you put under judicial hold.
Okay, got it. Because we weren't going to handle those in light of this one.
Correct.
Understood. Okay. So Mr. Menendez, knowing that my goal is to get Mr. Wolf on that late February trial calendar, any reason that seems too close in time for you to get through what remains?
Not at all, Judge. And also just to comment about the motions, I did file several, preliminary motions that need to be particularized. So that was my question of complying with the court standard, what needs to be particular based on when I just everything. I can be ready for February trial. I'd like to have a motions date sometime in January. And then also I overheard the court's discussion YSL case, and I also represent a defendant. It's just heads up to the court.
Okay. As I said, most of the world will grind to a halt when YSL starts. But if Judge Glanville decides to move forward with a subset, then if you're not in that group, I'll expect you to be ready to roll in February. What I'm going to ask you to do, rather than me setting a motions date, is that you would let Ms. Nelson know and Mr. Hiles, hey, here are some motions that require an evidentiary hearing in advance of trial. We'll make time for that, but I don't want to block out time for that if it is, maybe we would use it. The date for us to have heard particularized motions that you should have already filed has come and gone, which doesn't mean we can't find another window. I just don't want to block that out if there aren't going to be particularized motions. You may have motions in limine. I don't want the state referring to my client as Killer Ricky or whatever. And we could argue those, but that we could argue while we're waiting for jurors to show up. So we can work through those at the appropriate time. Mr. Hiles, are there discovery concerns you have, as in there's more coming and you're not sure if February would give you enough time to get it to Mr. Menendez?
Only thing I could think of is his co-defendant has some that I was made aware of, 2 cases in CP land. I will make a charging decision on those by the end of next week. I don't know if I would try to reindict and include them in this. I've got to get my hands around all that information, but I will have that by the end of next week. The other, I'm meeting, I've been trading emails with Miss Wood. I'm meeting with Miss Wood to go over some discovery on Wednesday next week on the 16th of November. She was having trouble opening some of the phone records. I don't know if Mr. Menendez is having the same issues, but maybe if Mr. Menendez is available, he could just hop in, and that way we could just do one meeting instead of two meetings.
Yeah, I am available for that.
Okay, well, I'll reach out and we'll get that in.
Good. I like that plan. Getting with both of them would be good. And we'll get Mr. Batten on here in just a minute. So we'll talk about his CP cases in a minute, but those don't directly implicate Mr. Wolf. They're Mr. Batten's business, not Mr. Wolf's business.
Well, in the sense that if they come with gang charges, that would be probably part of this, and I would argue it admissible against Mr. Wolf under 1659. But I got to get all that. I got the charges outlined, but I need to see the evidence before I make a decision one way or another.
Got it. Okay. Well, you'll work through that. And as I said, we'll talk with Mr. Batten in just a second. Mr. Wolf, do you have any questions about what we've been talking about?
No, sir.
Okay. And again, bottom line, your case will be on our February trial calendar. Mr. Menendez will be getting the rest, working through the rest of discovery soon and spending time with you talking about that and spending time with the prosecutor talking about that. And we'll look to see you, if not for a motions hearing before then, for a trial calendar in February. Mr. Menendez, anything else on behalf of Mr. Wolf?
No, Your Honor, I believe that's all at this time, and I'll keep the court updated about any motions.
Sounds good. Thank you.
All right, thanks. Good to see you, Judge.
Same. All right, Mr. Wolf, you are free to go. Let's try to get Mr. Batten. Hey, Mr. Batten, is that you?
Yes, sir.
How you doing this afternoon?
Good.
Good. Ms. Wood, this is your client?
Yes, Judge.
Great. Let me get you there next to Mr. Batten. So, Mr. Batten, I don't know how the booths work where you are. Were you able to hear a bit of the conversation I was having with Mr. Wolf's lawyer and the prosecutor?
Yes, sir.
Great. So we don't need to replay all of that. Ms. Wood, why don't you give me your update on discovery in Mr. Batten's case?
Yes, Judge. So like Mr. Menendez said, there is a lot of it. I am having difficulty opening some of the cell phone records. I did reach out to Mr. Hiles because I'm not sure if it's my laptop or what, but we are going to meet next week just to, compare files and see if it's on my end or if it needs to be reshared. So I guess you said February trial calendar is what we're looking at for these cases?
Yes, ma'am.
Okay.
When you say phone records, does that mean Verizon and it shows just like this phone number called that, or it's phone records as in there was an extraction from a cell phone, and so it could be videos, it could be photos?
I think it's both are included. And it's different. It's cell phones that belong to a number of different people is part of the issue.
Got it. Okay. So I understand better now when you say it was hard to open some of these things. If it was phone records in the classical sense, as in a PDF or a spreadsheet from T-Mobile, I was confused by that, but it could be any form of media that was off of, it sounds like multiple phones.
Yes, Judge.
Okay. I just noticed the way this case is charged. I appreciate their co-defendants, but neither of them has the same counts. So Mr. Batten, there's allegedly an arson, and Mr. Wolf, it's a murder. How do we glue these together?
Your Honor, the allegations are that the arson is the destruction of the car that was used to perpetuate the homicide.
Got it. Okay. So I'm not reading it incorrectly, that if you were to map out the charges, Mr. Wolf has a set of charges, Mr. Batten does. Neither of them is charged in the same count, but the state's theory would be these offenses ought to be joined in a single charging document because it's all one episode.
That's correct, Your Honor.
Okay, got it. So Ms. Wood, assuming that Mr. Hiles helps you navigate some of these hard to open files, is a February trial date too soon or workable for you and Mr. Batten?
I think that's workable, Judge.
Okay. Are you familiar with the unindicted cases Mr. Batten has?
I am not. I was hoping Mr. House could give me those numbers.
I will share with you what I have. So I was trying to see the CP numbers associated with it. It came in with very large investigation in 2020 and 21 of stolen cars, and I don't think warrants were taken out. And so that would be the explanation of why it doesn't have CP numbers.
Okay.
So
all right, I'll let you guys work through that. What, just in general, what are the charges?
Theft by taking and theft by receiving stolen automobiles.
Okay. All right. So could very well be related. That's your theory, but it's not that you're adding a treason or a double homicide to the overall framework.
That is correct. I don't think it would be anything that would severely slow down the process.
Okay. Got it. Thank you. All right, Ms. Wood, anything else for Mr. Batten, or we're currently on track for trial calendar in February?
That's fine, Judge. You did sign my order so I could go visit him with my laptop. So Mr. Batten, we talked about that. And once I get the discovery issues sorted out, I'll be out to see him at the jail with my laptop.
All right, Mr. Batten, you have any questions?
Yes, sir. I was wondering about, he said charges being brought up 2021, 2022.
Can you say that again and maybe move back from the wall a little bit?
He said charges being brought up 2021, 2022, theft by receiving and theft by taking.
Yeah.
I'm trying to just wondering like more details about it.
Sure. So you're entitled to a whole lot more information. Mr. Hiles, the prosecutor, is going to track down some case numbers so that Ms. Wood can look them up in the system and let you know what the allegations are. Because we don't have any more information than that right now. Mr. Hiles is going to need to find a case number so that you can get, you're asking the right question, but Ms. Wood can't answer it until she gets the case number.
Okay.
I think I can explain a little better. There is not a CP number because these were part of a larger investigation that was turned over to our office, conducted by different agencies in Fulton County. And so I was just given an internal number for our office. So there's not at the moment any either pre-indictment CP number or anything of that nature. So I will just share everything I have with Miss Wood.
Okay.
Give it to him.
And then she can get it straight to Mr. Batten.
Correct.
Okay. Sounds good. Anything else, Mr. Batten?
I'm finishing up a 3-year sentence. I want to know, I want to get it resolved because I pled, you know what I'm saying? I pled guilty to my charges, what I did.
Right. So that's your other case that you're here from Autry State Prison. So we'll talk about all of that when I come see you. Okay.
All right. Sounds like a plan. She'll see you soon. Ms. Wood will be there. She'll have a laptop so that she can share with you some of the video and other digital evidence that the state has, and we'll keep things moving along. All right, Mr. Batten.
All right.
You're free to go.
Thank you, Judge.
Thanks.
Thank you, Judge. May I please be excused?
You may, if that's your only case.
Thank you. It is.
All right. So Ms. Livingston, I'm sorry, I only now noticed your note that you wanted number 12 to go first, but then I think you said courtroom 3 wasn't ready. Is courtroom 3 ready, or should I go to a different position?
They're ready now, Judge. He's sitting in courtroom number 3.
All right, I'll bring that on. Mr. Jones, are you still on? You are. Let me add you. Oh, you got to start your video.
Judge, I think I did.
You did. There you are. All right. And courtroom 3, you've unmuted. That's great. Can you hear me, Mr. Hanna? Great. Okay. And let me consult my other set of notes. Position 12. That's a Mr. Whitenauer case. Do we have Mr. Whitenauer yet? All right. Who's going to stand in for him? We're done waiting on Mr. Whitenauer. I mean, he's elsewhere. He's just stuck in other courts. Mr. Jones, tell me about discovery status of Mr. Hanna's case.
Judge, I haven't received the discovery yet. And he actually, he's been admitted into that program Beyond the Bars. You set a bond for him about a month ago. His family is close to making it, so he should be bonding out soon and get into that.
Good. So I've got a October 24th certificate of discovery from Mr. Whitenauer indicating that he sent you a bunch of stuff through a evidence.com link, the indictment, body cam, police report, GCIC, medical records, a warrant, and we'll make sure he sent it to the right place. Yep, your office. So presumably there was an email that went to you because that's how that evidence.com works.
I got it.
The docket says this happened now a few weeks ago, October 24th.
Judge, when my internet has been down at my office since yesterday, but when it gets back up, I will hunt for the discovery.
Okay, please do and reach out to Mr. Whitenauer if you can't find it. But he's certified to me and you in this filing that on October 24th, that was made available. So please do look for that. Assuming that there's nothing in the discovery that requires a whole lot of motions practice, any reason why we cannot move Mr. Hanna's case to a trial calendar?
No reason that I'm aware of, Judge.
All right. Mr. Abate, I assume Mr. Whitenauer is ready for this to keep moving?
Yes, Your Honor.
Great, we'll do that. Mr. Jones, if either you cannot find that email, well, if you cannot find the email and Mr. Whitenauer is refusing to share discovery with you, which would be a surprise to me, please let Ms. Nelson know so that we can make sure that this moves along. What I do not want to have happen is it's trial calendar time, and then you say again, I don't have discovery in this case. I'm shifting the burden to you. I know it's their burden to produce it, but I have circumstantial evidence they did produce it. So if I don't hear anything from you over the next few weeks, that tells me that you did get the discovery from Mr. Whitenauer, and it is from your evaluation, the complete discovery. Okay?
Judge, I will let Ms. Livingston know if I don't have it.
Great. Sounds like a plan. Make that Ms. Nelson though. All right. Mr. Hanna, do you have any questions about anything?
Yeah, I really need to speak with my lawyer.
Okay. So, Mr. Jones, when would you be able to connect with Mr. Hanna so he can hear you say it?
I could probably go out to see him on Friday.
All right. I assume you'll be around, Mr. Hanna, if Mr. Jones is able to make it out there on Friday?
Yes, sir.
Great. You guys can have a conversation then, and Mr. Jones may then get an update from you about, well, I guess you've been accepted into Beyond the Bars. It's a question of your family posting that bond. So maybe that's where things can end up.
And I learned from them today they're close.
Okay, good. And Mr. Hanna, you're in the Marietta Annex because you're doing K-9 cellmates right now?
I graduated from there. Now I'm a trustee.
Okay. And when you're a trustee, you stay at the annex?
Yes, sir.
Excellent. All right. Glad to hear that. Mr. Abate, anything else in this case?
No, Your Honor, if he has any trouble, he can reach out to me before he reaches out to Miss Nelson, AKA Miss Livingston.
All right, sounds good. You got a number of folks willing to support you, Mr. Jones. This will be on the January trial calendar. So if it is not resolved before then, that's when I will see Mr. Hanna next. Either he'll be dressed like that or he'll be dressed in street clothes because his family posted the bond and he can give us an update about beyond the bars. Okay?
Thank you, Judge.
You're welcome. You are free to go, and you are free to go, Mr. Hanna. Thank you, courtroom 3. All right. Let's do Mr. Stokely. Is Mr. Herrick on?
Judge, I believe he was having trouble connecting, so I guess you can announce who his attorney is, because he did do an entry of appearance.
Okay. Did he tell you anything more other than I'm having trouble getting on? Or that's just...
He was in 2 different courtrooms in 2 different counties. So he emailed me early this morning, said he may have a problem attending. I sent him the Zoom information and then his computer was out of juice, so he was not able to join.
Okay, well, let me at least get Mr. Stokely going here and we'll talk briefly about that. North Park 2. Mr. Stokely, can you hear me?
Yeah, I hear you.
Great. So you have an attorney now? I know for a while we've been spinning our wheels trying to get you one, and that's Mr. Herrick, Herrick. He filed an entry of appearance in your case. I've never met him. I hope he connects with you soon. Our court actually undertook some pretty serious efforts to get a bunch of attorneys for cases like yours, and just before we could get cases assigned to them, Mr. Herrick and a gentleman with the last name of Ragus swooped in and filed entries and then disappeared. So we'll see what's going to happen. Mr. Abate, I assume you haven't had a chance to get discovery to Mr. Herrick because you may not have met him either.
I have not met him yet. No, sir. I saw he entered, I think, the 24th of October and haven't heard any further communications with him.
Oh, okay. Well, what we will do without bothering Mr. Stokely again is get Mr. Herrick connected with you, make sure he can get the discovery in the case, and then he can provide an update to Ms. Nelson as to where he thinks we are in the matter. He'll obviously need to start working with Mr. Stokely as well. We had put this on the calendar just to see if anything had changed, and the good news is something changed. A lawyer filed an entry of appearance on behalf of Mr. Stokely. How voluminous is discovery in this case? I assume there are a bunch of accident reports.
It's in the, I guess, the realm of voluminous discovery. I would say it's not that bad.
Okay. All right.
And the case is very resolvable. So Miss Nelson provided the cell phone contact information for Mr. Herrick a minute ago. So I will give him a call this week.
Great. Okay. Mr. Stokely, other than me trying to get Mr. Herrick to come out and see you so you can meet your lawyer, anything else going on that you want to talk about? Okay. Well, we'll get Mr. Herrick out there and he can start moving your case forward. You're free to go. All right. Let me review where we are. We got to go back. I don't know why we skipped position 2. I think because someone else was in his booth. If you are DeMarcus Dixon, raise your hand. Looking for him. There he is. All right. Booth 2. Good afternoon, Mr. Dixon. Thanks for your patience. Let me see. Ms. Wood, this is your case.
Yes,
And
Judge.
it is Mr. Shapiro's case. Say my notes. I know he is in trial right now.
I'll be Mr. Shapiro as well.
All right, so many hats. So this is plea and arraignment. Ms. Wood, what's happening with Mr. Dixon?
Judge, we're gonna waive arraignment in our plea of not guilty. I filed the substitution of counsel as well as the waiver of arraignment. He, as you see on the calendar, he's got those 2 CP cases, and then I was made aware he's got a third 22 CP 213455. I am working to get my hands on those files to see if there's the possibility of resolving everything at once.
Okay. Have you reviewed what the charges are in those other cases, not so that you can recite them to me chapter and verse, but so you can let me know they are more resolvable than these types of charges, or they're less resolvable than what we've got in the indicted case?
I know one of them is very similar to what's in the indicted case,
Okay.
and my Odyssey just went down, so I can't remember what the other 2 are.
That's all right.
And
Okay.
I will be out to see Mr. Dixon soon. You're on my list, Mr. Dixon.
Great. All right. So Mr. Shapiro will need to get discovery to Ms. Wood. In this case, she's filed the waiver of arraignment and entry of appearance. Mr. Dixon, it sounds like you've got a few fish to fry here with the unindicted cases, and then this set of charges, at least on paper, look very serious. You, of course, are presumed innocent of all the charges, but there are a bunch of moving parts here, and Ms. Wood is trying to get her arms around all of them. And she'll be talking to you in particular about this case that charges you with shooting at a couple people, and as well as your other cases, which may be as many as 3 unindicted cases. Those cases, if they get indicted, will be assigned to me. So you'll be dealing all with one judge, and I'll just make sure we're moving your stuff along because you're stuck in jail and I'm sure you want to be somewhere else. Do you have any questions about what we just talked about?
What indicted case?
So the indicted case charges you with, I'll give you the specifics. I'm not going to read all the language, but it may ring some bells. It alleges that on July 5th of this year, so real recently, you shot Jania Jones and you shot at Ralia Edwards Holland, someone you were living with. You also threatened Ms. Jones, and I guess I didn't realize this. Jania Jones is a kid. She's under 18. So it's an allegation of basically shooting Ms. Jones and shooting at that other, I think that's a female name that I mentioned. So that's the base. You don't need to be talking about it with me. You should talk about it with Ms. Wood, but that's what the indicted case is about. Okay. You have other questions?
Do I have a bond on any of them?
You do not. You were denied bond by a magistrate. So one thing Ms. Wood will talk to you about is bond. I'm gonna let you know right now, 1, those are pretty serious charges, but 2, if you have 3 other open cases, bond is gonna be a pretty high reach for you. That doesn't mean you shouldn't ask for it. And Ms. Wood is the right person to talk to about that. And she's told you she's gonna come see you pretty soon. And that'll probably be top on your list is when I gotta get out of here. And she can give you a sense of what the landscape is like, given that you've got an indictment for something as serious as this and 3 unindicted cases, at least 2, maybe 3. Any other questions?
I talked to her about it.
Good. That's a good thought. Ms. Wood, anything else on behalf of Mr. Dixon?
No, Your Honor.
All right, Mr. Dixon, thanks for your patience today. You're free to go. So we still have Mr. Kelly. Let me mute that. We still have Mr. Kelly, and I'll make sure he's gotten pulled out of that breakout room. We've got Keith Berry and Mr. Bethea, who I'm going to hold off on for a minute. I I guess someone can be Mr. Whitenauer for Mr. Barry as well. Let's shift back to him. 9. Oh, walking right in. Your stunt double was not nearly as handsome.
Oh, thank you, Judge.
So you can get situated. We're going to do Mr. Barry. I have to turn his audio on. All right, Mr. Barry, can you hear us?
Yes, sir.
Great. Oh, wait, there's always one more moving part. Let me look here. Number 9. I don't know who represents Mr. Barry.
That's my case, Your Honor. I filed a substitution of counsel today.
Great, thank you. So Ms. Feely, let me get you on the screen so Mr. Barry can see you. There's Ms. Feely. Great. There is another case, a newer case that just got to us through green sheeting. And so we need to talk through process here. This case, a family violence ag assault gun case, is on to figure out if we can move it to a trial calendar, which is where it ought to go. But there is this newer case that ideally would move along with it. But I don't know how serious those charges are and if it's the kind of case that could catch up. Although I'm pulling up an Odyssey. Look at that, aggravated assault, aggravated stalking. Similar victims?
Same victim.
So it needs to move together. It doesn't make sense for it to be apart.
Yes, Judge.
Okay, all right. So let me start with you then, Ms. Feely. How do you want us to manage these two cases? The state obviously picks which one it would try first if this is going to involve a trial, but you need to be in a position to meaningfully counsel Mr. Barry on both.
Yes, Your Honor. So I have discovery on the case that's on the calendar. I don't think I have it yet on the one that was arraigned a couple of weeks ago, but I expect it's going to be, I know what to expect, I think, on that one. But this is one where I think Mr. Whitenauer is well aware that the complaining witness is very vocal and insistent about not wanting to participate in the prosecution of Mr. Barry. So that's another reason I think these two should move together. So we're just hopeful to get, and I will continue to work with Mr. Whitenauer on a global resolution as well.
So should we, excuse me, so Mr. Barry's, the case on the calendar, we'll call it that way, the one ending in 437, that's already tentatively slated for a trial calendar, either January or February, I don't know which. Should we leave it there or should we take it off that to allow the newer case to catch up with it?
I would prefer to leave it there tentatively at this point.
Okay, I think that makes sense. We can always pull it off if the newer case has gotten bogged down, but then at least there's a placeholder for Mr. Barry if their negotiations don't go well. And I don't know that this is a bond situation, but it could be depending on what the alleged victim has to say in court. But for now, I think keeping Mr. Barry's older case on track for a trial sooner rather than later will help keep people focused on it. So we'll do that. You have any objection to that, Mr. Whitenauer?
No, Judge.
Okay, so we'll move the case ending in 437 to a trial calendar. If you could, you had no way of knowing Ms. Feely was the lawyer until very, very recently, but if you could get discovery to her ASAP, then she can meet with Mr. Barry to say, here are the two universes we're dealing with. It sounds like there's some overlap in terms of the alleged victim, but that they're two separate events. Just ballpark, if you know, are they separated in time by 5 days, 5 months? And if you don't know, that's fine.
I have reviewed both cases, Judge. I don't know off the top of my head.
Okay, are they the same year?
I think so.
Okay, but I'm not holding you to that. I'm just curious. There's certainly separate events.
They are.
Okay.
And just, I want to be clear, Ms. Feely believes that she has received the discovery from 437, but she's looking for 295.
Yes.
Okay, just want to make sure.
Yeah, that's my understanding as well. All right, Mr. Barry, do you have any questions?
Yes, I was wondering because I was out on bond for all this stuff and, the court was set, the court date to the wrong address, which gave me a failure to appear. So now I'm sitting behind bars. I got a lot of stuff going on, legit, businesses and I work a legit job. And I just recently had a newborn. I just like some type of bond status or something.
You do have a lot going on, Mr. Barry, and I'll talk with you about the motions that need to be filed.
Okay, so I didn't realize Mr. Barry is in right now on a FTA, a failure to a bench warrant.
And I don't think he has a bond on the new case either.
Okay, all right. So there are a couple reasons why you're in. And Ms. Feely will come see you soon. She probably wants to have in hand discovery from that newer case as well. And then she is your advocate. And if she and you decide that it makes sense to come before me to talk about bonds, she'll make that happen. And we'll do that. So you're not fighting this one solo, Mr. Barry. Just meet with Ms. Feely when she comes out in the next week or so, whenever it is. And you guys will develop a plan. Do you have other questions?
No. I just would like to get this taken care of as soon as possible.
All right, I hear you. That's what we're trying to do. All right, Mr. Barry, thanks for your patience. You're free to go. All right, so I think we have Mr. Kelly and Mr. Bethea left. What do you want to, let me fish Mr. Kelly out of the breakout room if he's in there. Do it the hard way. 5 North Booth 1. All right, he's back. And then Dixon. All right, Ms. Wood, you still with us?
Yes, Judge, I'm here.
All right, we have Mr. Kelly here as well. Let me unmute him. What are we doing with Mr. Kelly's case?
Judge, we are so close to a negotiated plea. However, I'm going to go ahead and waive formal arraignment today, enter the plea of not guilty. Ms. Charles and I are working on this one. The last piece of the puzzle is just to confirm the residence to where he will be returning upon release. And I think I actually need to involve my investigator on that one. So I filed the waiver, I filed the substitution of counsel. And so if we could just get a scheduling order going on this one, I think that'd be great.
We'll do exactly that. So Mr. Kelly, it sounds like Ms. Wood has been doing some real good negotiating on your behalf and is close to resolving things. And you may have a place in mind where you're going to live when you get out, but there just needs to be a little bit of verification or cross-checking of that, okay?
Yes, sir. Like she was saying, that I have 48 hours to report when I do get out. And,
That could be, this is being report to probation or report to register?
register.
So, Mr. Kelly, that's something that we'll go over more in depth when I come see you. I know a lot of the times the confusion is reporting to probation and also the sheriff's department for the registry. So we'll square all of that away before we actually do a plea.
Okay, so.
Okay.
So when will you be to see me?
Next week.
Okay.
Okay.
All right, so Mr. Kelly, as I understand it, your case is real close to resolving. There's just that little piece of something about the housing and you reporting that need to be ironed out, okay?
All right.
All right, I will see you soon.
Okay.
All right, you're free to go. Thank you.
Thank you, Judge.
You bet. Mr. Bethea, can you hear me?
Yes, sir.
Great. Let me see what info I have. Mr. Hand and Ms. Wood, are you the right folks for this case?
Yes, Judge.
All right. I think Ms. Primovic may have been helping out with Mr. Bethea last time. That was my recollection. I tried to make clear to folks on both sides that this is a delicate situation with this defendant and his history in the community, the nature of his repeat offenses, and the community's serious concern about him. So I just want to make sure we are thoughtful about how we handle this. I don't have the petition in front of me, but maybe I can find it in Odyssey.
I have a copy as well, Judge, if you
Okay.
want to see it.
Thank you.
Yes.
All right. So before we sort out tell me, Ms. Wood, what you think is happening today. Are we working through this warrant?
Judge, I was going to request one more reset. The reason being, after the last court date, where I was involved with Mr. Bethea, after our discussion, I reached out to Ms. Patterson. She got involved. She recommended accountability court. We made the referral. They did their interview. That did not work out. And so we are back to the drawing table. Ms. Patterson is trying to find a creative but appropriate resolution for this. And so I'm asking for one more reset to see if we can come up with something before we actually move forward with the resolution.
Okay. And just so we're all focused on the same concern, the warrant that I signed has an allegation that Mr. Bethea, upon release from prison in July of this year, failed to report to probation. There was no good address on record. When probation reported to the household that was on record, the person who lived there said, nope, that's not Mr. Bethea's place. And phone communication didn't work either. So basically, Mr. Bethea had fallen off the grid, and that was concerning to probation. It's concerning to the community that was concerned about what Mr. Bethea has a history of doing. And so I wanted to make sure we had a very carefully structured response to this. So, Mr. Bethea, do you have any questions about what we're talking about?
Sir, no, sir.
Okay. Ms. Wood, who is working on your behalf, is going to come out and visit you. Either she will or a colleague of hers, Ms. Patterson, or both of them will, to talk to you about different programs they might be able to get you into. Does that make sense?
Sir, yes, sir. It don't matter what y'all do, man. It don't matter what y'all do, sir. You got to go ahead and do something, proceed with something. It don't matter what y'all do, man. It don't matter what you do, period, man. You got to go ahead and proceed with something, man.
Why do you say it doesn't matter what we do?
It don't matter, man. You go ahead and proceed with something. It don't matter, man.
Mr.
Okay.
Bethea, I will be out to see you and we'll talk about the next steps, okay?
Man, it don't matter, man. Just go ahead and proceed with something, man. It don't matter. I don't get out either way it go, man. I don't get out either way it go. Go ahead and proceed with something, man.
Okay, I hear you. We may take a couple other steps as well. Mr. Bethea, anything else you want to talk about?
No, I don't want to talk about that, man. I want to talk about that.
All right, hold on 1 second before I let you go. I know you've been real patient. Mr. Hand?
Yes, Judge, at the last hearing with Ms. Wood, the state was intending to stipulate to a 60-day revocation, if you remember that.
I do, and I was not willing to stipulate to a 60-day revocation.
Exactly, Judge. And so I just wanted to say for the record that the state is no longer intending to do that, having looked into concerns that you raised, including articles about Ms. Bethea and his previous offenses in the community. So
all right.
I just want to put that on the record, Judge.
All right. Well, understood. I think we still need to focus on some outcome for Mr. Bethea, and it may well include a program that Ms. Patterson and Ms. Wood are able to find. Mr. Bethea obviously has a say in that as well, and he's saying some things now about it. So we'll work through all of that. Mr. Bethea, any other questions at this point?
No, ain't no question, Judge. Ain't no question, man. Just go ahead and proceed, do whatever you want to do, man. Ain't no question, man. Ain't no
All right.
question at all, man.
Got it. Well, Mr. Bethea, I appreciate your patience. You don't have to stay in the booth anymore, okay? All right. So, Ms. Wood, I appreciate that you continue to work on this one. I don't know exactly what regimen Mr. Bethea is on out there. I know what floor he's on, but it may be that we need to intervene in a different way, because I don't see how any program would say we're the right program for Mr. Bethea right now.
And Judge, I just wanted to let you know, I saw him within the past 2 weeks and he was very calm and able to talk to me. So yes, I will look into that. I'll see him again soon and see if something else needs to be filed.
Okay, great. He was not like this the last time he was on Zoom. So I worry that there's a medication misfire or he's not taking something. And so at a minimum, maybe you could inquire when you are out there to interact with the medical folks to see if something has changed in what he's taking or what he was prescribed.
Yes, Judge, thank you.
All right, thank you. I think that's it for the calendar. Mr. Hand, anything else from the state?
No, Judge.
All right, Ms. Wood, Ms. Feely, did we skip anyone? Didn't mean to.
Nope, I think that's everything.
All right. Well, Ms. Livingston, thank you so much for lining everyone up. Sorry we went slightly out of order, but I think we took care of everything.
Yes, sir. You're welcome.
Ms. Jackson, Ms. Tucson, thank you for being here in case we got a plea. We were so close on one of them, it sounds like. And we'll keep trying.
Thank you.
All right. Everyone on the call is free to go. Thank you so much.